recognizing the issues, recognizing the evidence, and determining the issues on the basis of the evidence. So I submit with respect that it is fundamentally different, and I would also suggest that your judgment would obviously make it plain that this is not a case in which a court is criticized for not mentioning a piece of evidence or an issue in its judgment. This is not a case in which a court is criticized for overlooking a little bit here or a little bit there. The SCA majority failed altogether to identify the issues, to identify the evidence, and to determine the issues.
My next question is whether Section 34, the purpose thereof, is not really focused on the procedure, whether a person has had a right to a fair hearing. And if you've had a right to a fair hearing and a judgment is imperfect, can you then rely on Section 34?
Well, Section 34 entitles one to a fair hearing, which this court has held is fundamental to the rule of law. And a fair hearing would include a fair determination of the issues before the court on the basis of the evidence before the court and the submissions of the parties. In this case, the court disregarded the issues, disregarded the evidence, disregarded the submissions, and didn't even determine the issues. So we submit that it was a fundamentally unfair hearing because the court did not determine the issues on the evidence before it.
Mr. Trengrove, you do know that in this court, well, I'm assuming you do know, because of your take this as a compliment. We are aware that this court is inundated with applications for leave to appeal. I'm thinking that if we start entertaining purely factual to be the jurisdiction of this court.
No, that's quite correct. And this court has made it absolutely clear that a mere dispute of fact does not engage the jurisdiction of this court. And even a constitutional issue, well, even a dispute of fact under constitutional garb also does not trigger the...
Even a misapplication of the law.
Yes, indeed. But we submit with respect that it is fundamentally different when a litigant complains that I did not have a fair hearing. In fact, I did not have a hearing at all before the Supreme Court of Appeal. Because a hearing, performance of the judicial function under Section 34 does require an identification of the issues, identification of the evidence, and application of the evidence to the issues. Now, if a court performs that function, then the mere fact that it might make mistakes in doing so is not a constitutional issue, and this court will not afford leave to appeal. But when the court fundamentally fails to perform that very basic judicial function at all, then we submit with respect that that is a constitutional issue. That's a breach of the rule of law, because the court did not even perform the judicial function substantively as opposed to perhaps formally.
Well, in this case, what you are saying, because in your submissions you compared the majority judgment and the minority judgment. And what I'm understanding to be a complaint is not that you did not get a fair hearing. You are simply saying even when you compare the majority judgment and the minority judgment, there are certain issues that were taken into account by the minority judgment, meaning that you did get an opportunity and you did get a hearing from the court, and it was fair. But you are saying that the majority as compared to the minority